Before we jump in, I do earn a referral fee when you use the services and companies I demonstrate in the video, but there is no additional cost to you. I chose them because they're the best in the industry and you're safe with them.
Ever wondered why setting up a trust for real estate can be a game changer? Well, let's shed some light on this intriguing question. A trust in the realm of real estate is essentially a legal entity that holds property or assets for a person or another entity. Establishing a trust for your real estate assets can be a smart move for various reasons. Firstly, it helps you avoid the often lengthy and costly probate process that comes into play when assets are transferred after death. Secondly, a trust provides a level of privacy that's hard to match, as it keeps your estate affairs out of the public eye. Lastly, it offers substantial asset protection, shielding your real estate properties from potential creditors or lawsuits. These benefits make trusts an attractive option for real estate owners looking to secure their assets and ensure a smooth transition for their heirs. So now that we understand the significance, how exactly do we set up a trust for real estate? Let's dive in. First things first, deciding on the type of trust. There are two main types you'll want to familiarize yourself with: revocable and irrevocable trusts. A revocable trust, often referred to as a living trust, offers flexibility. It allows you to maintain control over your assets, make changes, or even dissolve the trust entirely during your lifetime. On the downside, revocable trusts may not offer robust protection from creditors or lawsuits. On the other hand, an irrevocable trust is, as the name suggests, not easily changed or dissolved once established. This rigidity may seem daunting, but it's worth noting that an irrevocable trust can offer significant asset protection, potentially safeguarding your real estate assets against creditors and legal disputes. Remember, each type of trust carries its own benefits and drawbacks. Your choice should align with your goals, financial situation, and risk tolerance. Deciding on the type of trust is a crucial step that can shape the future of your real estate assets. Once you've decided on the type of trust, the next step is to identify the trust assets. This process may seem straightforward, but it's actually quite meticulous. It's crucial to clearly identify and list all real estate properties you wish to include in the trust. This isn't just about jotting down addresses. You'll need to include specific details such as the type of property, its current market value, and any outstanding mortgages or liens. Consider hiring a real estate appraiser to ensure accurate valuation of your properties. Also, consult with your attorney to understand any potential tax implications. It's important to remember that not all properties may be suitable for inclusion in your trust. For instance, some properties with negative equity might be better off outside the trust. And don't forget about personal belongings of significant value. They too can be considered as trust assets. Remember, a well-defined list of assets is the backbone of your trust. Having listed the assets, it's time to select a trustee. You might wonder, who is a trustee? The trustee, simply put, is the person or entity who holds legal title to your trust assets and is responsible for managing and distributing these assets according to the terms of your trust agreement. A trustee can be an individual, such as a family member or friend, or a corporate entity, like a bank or trust company. Now you might ask, why is it so important to choose the right trustee? Well, the trustee not only manages your real estate assets, but also makes critical decisions about them. They need to be trustworthy, financially astute, and capable of handling any legal issues that may arise. The trustee's capabilities can significantly impact the growth and preservation of your trust assets. Choosing the right trustee can make all the difference in the effective management of your trust. With the trustee in place, we move on to drafting the trust agreement. This step is crucial, as it's the document that lays out the rules for managing the real estate within the trust. It's like a blueprint for the trustee, providing guidelines on how the assets should be handled. A trust agreement needs to be detailed and comprehensive. It should cover all possible scenarios and be clear about the responsibilities and powers of the trustee. Remember, it's not just a legal document, it's a roadmap for your trustee to follow. Let's delve into the key elements your trust agreement should include. Firstly, the name of the trust. This is more than just a label. It's how the trust will be identified in legal documents. Make sure it's unique and easily identifiable. Next, the trustee. This is the person or entity you've selected to manage the trust. Include their full legal name and contact information. In the event of any issues or disputes, this information will be vital. Thirdly, the beneficiaries. These are the individuals or entities who will benefit from the trust. In most cases, this will be your loved ones or a chosen charity. Be specific about who they are and how and when they will benefit from the trust. Lastly, the terms of the trust. This is where you outline how the trust is to be managed and how the assets are to be distributed. Be as detailed as possible. Specify when and how the real estate properties within the trust can be sold, rented, or otherwise used. Remember, the more specific and detailed your trust agreement is, the less room there is for confusion or misinterpretation. It's always a good idea to get a legal professional to help you draft this document to ensure it's legally sound and comprehensive. A well-drafted trust agreement is the cornerstone of a successful real estate trust. Finally, it's time to transfer the real estate to the trust. This step, often overlooked, is the linchpin of the entire process. Without it, the trust is nothing but an empty vessel. So let's get down to the nitty-gritty. Transferring real estate to a trust involves a legal document known as a deed. This deed, in essence, is a ticket that allows your real estate to hop onto the trust train. But remember, the deed must be executed correctly, or it's as good as null and void. This means ensuring the property description is accurate, the trust's name is correctly written, and the deed is duly signed, witnessed, and notarized. Once your deed is shipshape, it needs to be recorded in the county where the property is located. This public recording cements the transfer and alerts the world that your real estate now belongs to the trust. And there you have it. Your real estate is now safely tucked away in your trust. So, let's quickly recap the steps of setting up a trust for real estate. We kicked off with the decision-making process on the type of trust that suits your needs best, whether it be a revocable or irrevocable trust, each having its own pros and cons. Next, we navigated through the process of identifying the trust assets. It's essential to have a clear understanding of what constitutes your property, from land to buildings to even mineral rights. We then moved on to the selection of a trustee, a crucial decision as this individual or institution will manage your trust. They should be trustworthy, competent, and ideally have some knowledge of real estate. Then came the drafting of the trust agreement. This legal document outlines the rules of the trust, and it's where you make your intentions known. Finally, we covered the process of transferring your real estate to the trust, a legal procedure that ensures your assets are properly managed. Setting up a trust for your real estate might seem like a daunting task, but with these steps in mind, you're well on your way to securing your assets for the future.